Hi, I'm Scott Wyman, a Training and Technology Coordinator, Central Texas College, and I'll be your guide through this training session. Today's session, we're going to take a look at equal employment opportunity sexual harassment prevention training for managers and supervisors. This is part one of a two-part series. This section, we're going to talk about equal employment opportunity, and we'll also do some policy review as we go through. All right, so the purpose of this training is to improve supervisor and managers' awareness of discrimination and harassment and how it impedes productivity, decreases morale, generates negative publicity on the college. We also need to understand that there is a certain legal liability for CTC as well as individual managers, supervisors, and employees. Bottom line with this is pretty simple. Harassment and discrimination are illegal. Our objectives for this training are to explain federal and state EEO laws and CTCD's policies and procedures and how they relate to employment discrimination, harassment, and sexual harassment. Sexual harassment will be part two. We also want to explain expected behaviors and responsibilities of all supervisors, as well as answer any questions you may have. Naturally, I can't answer any questions directly. However, if you do have questions, feel free to give me a call. I'll put my phone number over here for you. I'll put my email address over here for you. And you can just give me a call whenever you need it. All right. We're going to start with some definitions. Definitions are important. You need to understand specifically what we're going to be talking about. And since we're going to be talking about unlawful employment discrimination, we will start with that. So unlawful discrimination is a behavior which occurs when employment decisions are based on any protected category under state or federal law. I'm not going to go deep into this. You probably already understand most of this, but I do want to point out two key parts to this definition. Number one, it must involve an employment decision. So just think of all the things you do throughout the day that could be considered employment decisions. It's quite a lot. And number two, it must be based on a protected category. And we'll talk about the protected categories here in just a little while. Next comes unlawful harassment, because harassment in and itself isn't unlawful. You can harass people because they like turkey sandwiches instead of beef, because they like French fries instead of baked potatoes. There's all kinds of stuff you can harass people about. However, if that harassment is repeated, unwelcome, offensive, slurs, jokes, or other oral, written, graphic, or physical conduct relating to any of the protected categories under state or federal law. So there's a couple important parts to this too. Number one, it must be repeated. A single isolated incident does not make harassment. That doesn't mean you can do anything you want once and get away with it, because it would most likely still be inappropriate for the workplace. And we need to focus on that as well as what's unlawful, because it's not a far stretch from unprofessional to unlawful. All right. So yeah, it must be repeated. Number two, it must be unwelcome. So how do we know something is unwelcome or not? Well, the easy answer to this is if the person on the receiving end of that behavior did not ask for it, then we can safely consider it to be unwelcome. And then who determines whether or not any given behavior is offensive? Not you, not the alleged offender, the victim, the person on the receiving end. And it doesn't even have to be the person on the receiving end. It could be any witness, anybody who sees it, anybody who hears it. So keep those things in mind, because there are a lot of different things that can happen that can create a hostile work environment. So I kind of already showed you or told you about unwelcome and how it's expressed. Again, if the person reporting or complaining about the behavior didn't ask for it, then consider it unwelcome. Pretty simple, right? I think that should make it easy. And also you need to keep in mind that what was once welcomed may become unwelcome. So I put up with it yesterday because, well, okay, you were just being childish or whatever, but I'm not going to put up with it today. So just because they said okay or they didn't complain about it the first time doesn't mean it's okay to do it again. So what we need to do is we need to watch out for these indirect comments that you may hear throughout your workplace. Things such as, I don't like it when he does XYZ or ABC or whatever it is. Maybe you would hear somebody say, I wish you would stop. I really don't appreciate that kind of behavior in the workplace. It makes me so uncomfortable. It just makes me uncomfortable when somebody does this, when somebody says that, okay? So it's not a complicated process. I don't think so anyway. So we're going to take a look at some federal laws. These federal laws prohibit employment discrimination, and they cover personnel decisions that could affect employees or applicants' employment opportunities. We need to remember that those folks applying for jobs here are covered under the same equal opportunity laws as those of us who already work here. So let me just throw out some numbers in regards to complaints filed at the federal level. Now these aren't all CTC complaints filed at the federal level. This is nationwide. So in calendar year 2025, the EEOC in Washington processed 91,503 complaints. That's a lot. Way more than we would ever expect. But it happens. And that's not even the highest number of complaints that have been filed. And I believe it was 2012, there were 99,000 plus complaints filed. So the number there for 2025 is a 3.4% increase from 2024. It's been on a steady increase since 2021, and they tend to associate that with the number of people returning back to work since COVID. Of those 91,000 complaints, 40 to 50% were retaliation. Retaliation has been the number one complaint with the EEOC for as far back as I can remember. Race tends to follow that one, and then disability. This particular year, those two have been reversed, to where disability is 35 to 37%, and race is 30 to 33%. Here on CTC, things have been a little bit different. We don't have near as many. In calendar year 25, there were only 4 complaints filed in our EEO office, as opposed to 1 in 2024. There hasn't been any steady increase or decrease here at CTC. They're just kind of here and there, splotchy. So the 4 complaints that were filed in 2025, 2 were age discrimination and 2 were sexual harassment discrimination. Just thought you'd like to see what's happening here on campus. All right, so now we're going to move on to Title VII of the Civil Rights Act of 1964. Under Title VII, there are 5 protected categories that are listed here. Again, I don't know that I need to go deep into these definitions because you've probably heard them before. Even if you're not, or even if this is your first time supervising, you've probably heard them before. But just briefly, race, color, religion, national origin, and sex. Those are the 5 protected categories. Different definitions, depending on where you look, depending on how you word your search in Google or AI. But I just found some generic definitions of each here for you to have a look at, right? Again, if you have questions, feel free to give me a call, shoot me an email. I'm always on Teams. You can contact me on Teams pretty much, 24/7, unless I'm in bed sleeping or in the shower, then I'm not going to reply. So these are what I call the big 5 protected categories under Title VII of the Civil Rights Act of 1964. These aren't the only protected categories. There are other categories that may stem from some of these categories. For example, Pregnancy is a protected category, but it's not listed specifically here, but it does fall under the main category of sex. So I pulled the protected categories out of HR Policy 220. They go a little bit beyond what they came up with in 1964. So here comes those protected categories. So you'll see a few additional, right? We're going to be looking at age discrimination. We're going to look at disability here in just a little while. The rest of these, you can find more information online if need be. But for now, this is what we have. Like I said, straight out of policy 220. Continuing on with Title VII of the Civil Rights Act of 1964, Title VII also protects us against retaliation. Anybody who participates, anybody who is involved with a complaint of discrimination or harassment are all protected against retaliation. What is retaliation? Well, in essence, it's taking some sort of negative action against a person who files a complaint or reports bad behavior. And this negative action doesn't have to be work-related. It could be personal in nature, such as ostracizing a coworker for filing a complaint, not inviting a particular coworker to a lunchtime meeting or something of that nature. Keep in mind, retaliation is the #1 complaint when people file in Washington with the EEOC. So be careful. And the part that really we need to keep a close eye on is this second bullet where it says the employer is liable if it knew or should have known about the conduct and failed to immediately investigate and take appropriate remedial actions. So in this case, we as supervisors represent the employer. We are it. If it's made known to us that someone is violating CTC policy on discrimination and harassment, it's up to us to take action to stop that behavior. If we notice a change of behavior in our workplace and we don't do anything to find out why, that could lead to a complaint of discrimination or harassment. And if you noticed something was off and you didn't do anything about it, well, you should have known that something was going on. So you have to be involved in your workplace. You have to be part of the solution, as they say. If you're not part of the solution, you're part of the problem. So just know the normal behaviors of your folks. And when you see that start to go a little wonky, you might start asking some questions. Title VII of the Civil Rights Act of 1964 also gives you 180 days to file a complaint from the time of the last or most recent incident. Right? 180 days from the most recent incident. So if that happens, then they can go farther back. But the most recent has to be within that 180-day time frame. Unless, of course, it's a complaint that can be filed at the federal level. Certain categories of complaints can be filed at the federal level with the EEOC first without going to anybody else. And if it's one of those, and again, you can find more information online. I'm not gonna spend a whole lot of time on the gooey details. But if it is one of those complaints, one of those categories, then the EEOC has extended that time to 300 days. 300 days to file a complaint. Don't wait 300 days. I never recommend waiting 300 days. I wouldn't even recommend waiting 180 days. I believe that if it happened today, I should report it today. Because the longer you wait, the more people forget. So it's best to take care of these things right away. So if somebody comes to you with allegations, take care of it right away. All right, so let's take a look at your responsibilities as a supervisor. First and foremost, apply standards equally to all employees. All employees should receive the same fair, equitable treatment. Avoid favoritism. Avoid ostracism. Try and treat everybody the same. Take all complaints seriously and immediately notify HR to assist in the process. All right? Somebody tells you something's happening, violates policy 220 or 221. You pick up the phone, you call the EEO office. Phone number is right here. And our folks will assist in taking care of this problem. Don't retaliate against those who file a complaint. This is, well, like I said, this is the number one reason people file complaints at the EEOC level. Retaliation. They've already attempted or made some sort of attempt to resolve it at a lower level, felt like they were treated unfairly because of that, so then they take it to a higher level. We don't want to be part of that. We've had complaints filed against us in the past, and we would prefer not to have any future filed against the college. We need to make sure that all employees attend their mandatory EEO training. I guess I should say complete their mandatory EEO training because it's all done online now. I got to say, supervisors have been a huge help recently. And by recently, I mean in the last, I don't know, 15 years. So if you get notification that one of your employees hasn't complied with their training yet, friendly reminder, hey, you need to get your EEO training done, right? That's all we ask. That's all we ask. Now we're going to take a look at the Equal Pay Act of 1963. The Equal Pay Act of 1963. This is an easy one. It prohibits discrimination in pay based on gender when the job circumstances are the same. That's the kicker part of this. The job circumstances have to be the same. Got a male and a female doing the same job, got the same education, the same training, the same experience. They should get the same pay. It's easy. It really is. We don't worry so much about this because at CTC, we all get paid off a pay scale. So a clerk 3 is a clerk 3, an office specialist is an office specialist, and a training guy is a training guy. So we all start at the same level. Now, if we have more experience or if we have more education, then that grants us a higher pay scale, but we all start initially at the same, which is good. It's good. But there are some employers out there who don't want their folks to discuss their pay. And if that happens, well, that could lead to certain problems. There was a young lady who worked for Goodyear in their Mississippi production plant. She was a production floor supervisor, worked there for years. After she retired, she found out that she was getting paid less than her male counterparts, even though she had more experience, more education, more everything except money. So she filed a complaint with the EEOC, and the EEOC said, that ain't right. Let's take it to court. They took it to court. The court said, that's not right. Goodyear, give her $2 million. Goodyear said, fine, but don't spend any of our money because we're going to get it back. And they went back and they regrouped and they come back and they went to the appeals court and they appealed the decision. And their grounds for appealing the decision, remember that 180 days? They said it's been way more than 180 days since this young lady agreed upon a salary. And that's what it refers to when you're talking about pay. From the day you agree upon a salary, more than 180 days goes by, you can't complain about unequal pay after that. That's the time frame, okay? The appeals court said, you're right, give her the money back. So Goodyear got their money back. The EEOC didn't think that was right. Needless to say, the young lady who filed the complaint didn't think it was right either. So the EEOC convinced her to come to Washington and lobby for the Fair Pay Act of 2009. This is her in Washington lobbying. Her name is Lilly Ledbetter. And all her work paid off because in February of 2009, President Obama signed into law the Lilly Ledbetter Fair Pay Act of 2009. And what it does is it modifies the filing time when it comes to pay. They have determined that every time you get paid, that's a negotiation for pay. If you don't think you've been paid enough, you're going to go in and you're going to say, hey, boss, I think I need a pay raise. That's a negotiation for pay. So every time you get paid now, that 180 days resets. Pretty cool. So the courts backdated the law 2 years, so Lilly got her $2 million plus 2 years back pay. Go Lilly. All right, so that's the Fair Pay Act of 2009 and the Equal Pay Act. Next, we're going to take a look at the Age Discrimination Employment Act of 1967. This one is in place, well, naturally to protect older folks. How old? Well, you have to be over 40. This law forbids age discrimination against people who are 40 or older. If you're under 40, you're not protected under the Age Discrimination Employment Act. There are certain tools in place to protect younger folks. But traditionally, if an older employee is chosen over a younger employee, it's because of experience. Okay. So that's age discrimination. Pretty easy, but it's also one of the most difficult to prove. So keep that in mind, right? All right, next comes the Americans with Disabilities Act. This folks, is a big one. There's lots of stuff when it comes to the ADA. In general, it prohibits discrimination by employers in personnel decisions based on mental or physical disability. 2, mental or physical disability. Can't always see these, so you have to be careful. In order to be protected under the Americans with Disabilities Act, an individual's impairment must meet the definition of a disability. And there's 3 ways that this can happen. First, the individual has an impairment that limits one or more major life activities. What's a major life activity, you ask? Well, it's an activity that an average person can perform with little or no difficulty. Things such as walking, the average person can walk. Breathing, the average person can breathe. Seeing, the average person can see, right? So if the impairment limits one or more major life activities. Number 2, if the individual has a record of that impairment, because not all impairments are outwardly visible. Take epilepsy or asthma or cancer. You can't look at somebody and see whether or not they have one of those 3 impairments. But if they have a record of that impairment and something should happen or they require some sort of accommodation, that letter will allow them to take care of that business. And then number three is kind of a catch-all, I guess you could say. This actually protects people with disabilities as well as people without disabilities. So if the individual is regarded as having an impairment, in other words, if you think somebody has an impairment and you start treating them differently, you're violating this law and they can file a complaint. We treat everybody the same. We hire people to do these jobs. At the interview, they should say, yes, I can perform these tasks with or without accommodation. And then once they get hired, if they need accommodation, that's when they present the disability. They should never disclose a disability during the interview. And as the interviewer, you should never ask if an interviewee has a disability. That's illegal. We can't ask applicants if they have a disability. We can't ask employees if they have a disability. If they have a disability and they want you to know about it, they have to come forth and tell you. In 2008, President Bush signed the Americans with Disabilities Amendments Act, and it made big changes to the term disability. And it changed the way that these terms should be interpreted, because a lot of things are up to interpretation, right? So what happened is they expanded the definition of major life activities. They created 2 non-exhaustive lists, which means they can grow as the need arises over time. The first list includes many of the activities that the EEOC already recognized, such as walking, reading, or seeing, breathing, that kind of stuff. But they also expanded it to reading, bending, communicating, because we can have impairments that can cause issues with any of those, right? The second list is probably the biggest one, because it includes major bodily functions, to include functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. So if an individual has any kinds of impairment with any of those systems, and they need some sort of accommodation, then we have to accommodate. Okay. All right. Again, our responsibilities when it comes to accommodation. If an employer knows that one of their folks has a disability and they need some sort of workplace accommodation, then they have an affirmative duty to make reasonable workplace accommodations. What's a reasonable workplace accommodation? Depends on money, right? It's all about money. If they can afford to purchase whatever is needed for that accommodation, then they must purchase whatever it is to make that accommodation. Okay? Pretty simple, pretty simple. Once a supervisor is made known that one of his or her employees has a disability, then they must engage in the interactive process to make reasonable accommodation. Best thing to do is get on the phone with the EEO office, and our folks there will work with you. They'll work with budget, and they'll do whatever they can, if they can afford it, to make those reasonable accommodations. So make sure you notify HR if anybody talks to you, anybody brings up disability. Okay, if they say the D word, if they say disability, stop the conversation, call HR. All right, moving on, we have the Texas Workforce Commission Civil Rights Division. They're down in Austin, and they support or enforce, they enforce is a better word, they enforce the Texas Commission on Human Rights Act. The TCHRA is kind of the Texas version of Title VII of the Civil Rights Act. The TCHRA prohibits employment discrimination in all personnel decisions based on the persons, and then follow that with the protected categories. These protected categories listed here are taken directly from the TCHRA. I went out and pulled them from the website. Any questions? No? Okay. Moving on then. Time for a little policy review. Again, this is a little deep, so I'm going to go kind of fast through parts of it. If you have questions, again, call me. You have my phone number. You got my email. I'm on Teams. Pull up the policy and read through it again if you need maybe just to refresh yourself. But the purpose is to clearly establish that CTCD prohibits harassment and discrimination by and of its employees, and to set forth procedures by which allegations may be made, investigated, and resolved. This policy applies to all employees at all locations. And if you bring a visitor on campus, or you're responsible for a vendor coming on campus, or your faculty, and you have students in your classroom, then it's your duty to make them aware of this policy, because this policy covers everybody on campus, not just employees. All right. Some definitions, we've already talked about a couple of the definitions. This definition we're going to talk about here in a little while. So I'm going to give you a second to look over that. And then we're going to move on. More definitions. We've already gone through unlawful harassment. There is our list of protected categories as of today in title or in policy 220. More definition. This is the discrimination, hostile work environment, right? So unlawful employment discrimination. There's the employment decisions. Remember, that's an important part of this. All right, the policy itself. Harassment, assault, or discrimination violation of this policy or any state or federal law is not tolerated. It is CTCD's policy that all employees should enjoy a work environment free from harassment and discrimination based on any of the protected categories in this policy. You as a supervisor are responsible for providing that work environment that's free from harassment and discrimination. It's not the employee's job to police other people in their work area. It's our job as supervisors to police everybody in our area to make sure everybody's complying and following the policies. If there's a violation, it's our responsibility because we have the power to administer discipline. We have the power to take action. Allegations will be fully investigated and could result in disciplinary action up to and including termination of employment. Also know that investigation materials, information will only be discussed on a need-to-know basis. Not everybody involved in the complaint process has a need to know everything that's going on. The complainant may feel like they have a need to know, but they don't. At the end, they'll find out whether or not their allegations were substantiated, and they'll be told that appropriate action was taken. They won't be told what action was taken, just that action was taken. CTCD and its employees shall not retaliate against any person, employee, or student who in good faith reports perceived harassment or discrimination. Keep that good faith thing in the front of your mind because I'm going to bring that up here in just a little bit. And then paragraph D just talks about training. New employees have to do the EEO training within 30 days of hire, and then every 2 years after that, we do the training. All right, some procedures. Any employee who believes that a supervisor, manager, other employee, or non-employee's actions or words constitute unwelcome harassment or discrimination has a responsibility to report or complain about the situation as soon as possible. Think about that for a minute. Well, not a minute, a second, right? Because what we're saying is that if somebody knows that harassment or discrimination has occurred, they have a responsibility to report or complain about that situation as soon as possible. Now, since issues are best resolved at the lowest level, employees are encouraged to discuss the complaint with the individuals who acted or behaved in a harassing or discriminatory manner. That's the first step in the reporting process. Ideally, they talk to the person who offended them or harassed them or discriminated against them and said, hey, I don't appreciate that. You know, that goes against CTC policy. I don't deserve that as a human being, whatever. But if they talk to that person, that's step one. They've reported that situation. To back that up, they should always notify their supervisor and tell them what happened. But it needs to be taken care of as soon as possible. And it's our responsibility. It doesn't say if you want to, go ahead. So if an employee doesn't feel comfortable discussing the problem with the individual, which they don't have to We just recommend you try that first. Then he or she should follow the reporting chain below. And it's just, chain of command, immediate supervisor, next higher level supervisor. If someone in the chain of command is the problem, then they can call straight up here and talk to our folks in HR. Okay. There's the phone number for our Chief Human Resource Officer right there. Here's where the Chief HR is located, building 557. That's the nursing building. In the back, C Wing, room C103. And there is the Chief's phone number. But also understand and make sure that the employee knows that they may be asked to provide a written statement to include names of witnesses. The sooner we get this done, the more witnesses we have, the easier it's going to be. And if the employee would prefer discussing the matter with an employee of another gender, then the Chief Human Resource Officer will make that accommodation. Continuing with the procedures, supervisors and managers will cover this subject area annually as part of a continuing education program. Did you know that? Did you know you're supposed to cover this policy annually with your folks? You sure are. I even created an e-treat form just for you. Let me see if I can dig it up here. Forms. Here, let me show you what I'm doing. I'm going to forms and I'm looking for EEO. And right here, Supervisor EEO Briefing Acknowledgement Form. So you just fill in this form. This is probably an important part right here where you list all of the employees that you briefed. And then when you click submit, this form will come to me and I will add that training to their training records. And I'll document in your training records that you provided that briefing and you'll be good to go for another year. All right. So it's not difficult, not even really that time consuming. It doesn't take long to just sit down and refresh their minds about this policy. And then this last statement, you'll see that it says the coordinator EEO training or coordinator employee training and the coordinator EEO are available to provide training on the law and prevention of harassment and discrimination if needed. I make house calls. I will come to your department and I will give this briefing personally if that's what you would like. So again, here's my phone number. Here's my email address. I'm always available on Teams. Just let me know. All right, so policy 210. This is our grievance procedures. It's important for people to know the process of filing a complaint. And it's really pretty simple. This is to provide a mechanism for employees to discuss complaints or problems with management and to ensure fairness and consistency in CTCD's relations with its employees. And it does apply to all employees at all locations. Again, I'm not going to go through the whole thing because it goes through, step by step. It gives the timeline in there. You have 5 days to do this and 10 days to do that and 15 days to do this. It takes a lot of time if I was to go through that. But I do want to bring up, I believe this is paragraph F in the grievance procedure policy. And it says any employee who knowingly files or should have known of the likelihood that they are filing a false or unwarranted complaint in an attempt to attack or discredit another employee or that disrupts the operation of CTCD may be subject to discipline up to and including termination. Remember what I told you to remember earlier? Anyone who in good faith reports harassment or discrimination, this is what I was referring to. If you know or you find out that they made this stuff up and filed a complaint, then action needs to be taken on that. All right, enough about policy 210. This concludes part 1 of Supervisor EEO SHP. Again, if you have any questions, feel free to give me a call. You got my phone number. You have my email address. And I'm always available where? Yep, on Teams. So feel free to give me a call if you need, and we'll go from there. All right. So let me pull up the next slide that you're going to need, because this is completion form instructions. Ah, yeah. So no action taken right now, but I do want you to write down this 4-character passkey. This is the first 4 characters of the 8-character passkey that you need for the completion form. So my passkeys are case sensitive, so the Q and the Z in this are lowercase. So 2 and a lowercase q, a lowercase z, and then the number 5. Again, that's the first 4 characters of the passkey that you're going to need for the completion form after you finish part 2. So with that, I'm going to say thanks for being here for part 1. I appreciate your time. Stay safe, stay healthy, and stay happy. And we'll see you next time.